nationalbusinesstraining.com. Globally recognized 100% online business training and certification programs completed in 5 months.
Managing member of Armor Compliance, which is a comprehensive compliance company. We basically provide outsourced chief compliance services to private equity fund and hedge fund advisors. And what I'm going to go through tonight is basically explain the Private Fund Investment Advisors Registration Act of 2009 and sort of tell you where we were and how we got here. A little more about me. I've been practicing law at the law firm of Bigham & McCutcheon for the last 3.5 years in their investment management group. And prior to that, I worked at Kirkpatrick & Lockhart in their Boston office in dealing with also with private funds and their compliance. And prior to that, I was at Latham & Watkins in New York and Boston, serving as a corporate lawyer. So I've been working as a lawyer for 9 years and recently launched Armor Compliance. So I'm happy to be here and going to kind of walk through tell a little story. I'm going to follow Richard's advice and tell you a little story. I'm going to go back to July of 2009, the night I saw this bill came down. I wrote a business plan. The Obama administration came out with proposed rules or regulations that would radically change the Investment Advisors Act of 1940 and change sort of the rules in which advisors are subject. And basically, in a nutshell, to avoid all the legalese, in a nutshell, what it said was, currently hedge funds have loopholes that they can get out of registration. Advisors to hedge funds have loopholes they can get out of registration. Private equity and venture capital funds have similar loopholes. And in essence, the proposed bill in July of 2009 said, look, if you are an advisor to a hedge fund, private equity fund, or venture capital fund, and you manage more than $30 million under management, you need to register under the Advisors Act and appoint a chief compliance officer. So it simplifies everything. It's an asset-based test. There's no more of the loopholes, if you will. So that set off a huge response throughout the industry. The National Venture Capital Association was up in arms, which they successfully lobbied we'll explain more. But that was, in a nutshell, that's what the complicating factor there is this would radically change the number of advisors that are subject to investment advisor registration. Currently, with all the loopholes, there's a lot of unregistered funds who manage billions of dollars currently unregistered under the Advisors Act. So we'll fast forward now, I think, to a lot of discussion back and forth. The National Venture Capital Association really got involved in lobbying, trying to prevent, saying we weren't responsible for this financial calamity that the United States suffered. Why should we be registered under the Advisors Act? It's overbroad. It doesn't really apply to us. So fast forward to October 1st, 2009, where the bill was formally introduced into the House and basically had all the same attributes that it had in the July proposal. The big exception is that advisors to venture capital funds were exempt, and suddenly the National Venture Capital Association was applauding Barney Frank, telling them what a wonderful congressman he was and such a great job he did keeping them out of this bill. So that was, surprisingly, I didn't realize that they had the lobbying skill in Washington that they did have, but I was very impressed that they did that, and was the main difference between that bill that was sort of introduced into the July bill to the October bill. Well, I'm actually really happy that I didn't prepare a PowerPoint because all the analysis basically changed on this past Tuesday, and it's actually, if you ever kind of want to see how government works, and it's actually a little depressing if you actually, I'm happy to, if you want to email me and show how the bill was changed, it's a little depressing if you email me. I'll show you the amendments that were made this past Tuesday to this bill, and it just seems as if there was really not a lot of forethought. In essence, Tuesday, October 29th, or October, I guess, 27th, 2009, the Financial Services Committee of the House basically passed 67-1 saying that we're in favor of this proposed bill, but with certain amendments. And if you actually go through, I went through all the amendments the other night, and it is a little depressing. First of all, this is something that probably lawyers know, is that a lot of these securities laws are based on what year they're passed. Like you've all probably heard the 33 Act, the 34 Act, the 40 Act. It's based on the year. Well, the first amendment they made to the bill was they changed the fact that whoever put the first October draft forward said it was the Investment Advisors Act of 1934. So the first thing is they were off by 6 years. The first thing they had to do was actually amend it and say it was actually the Investment Advisors Act of 1940. The fact that it went through so many eyes and nobody really caught that. It's a little shocking. The second amendment I think that it was significant was that basically is, there's a number of amendments that came down. These are all sort of, some were by roll call, other were by voice, and it just seemed, it's really quite a fascinating process. But back of the envelope, they've raised the asset test from 30 million to 150 million. They basically, it's 5 times that now. So apparently the small guys having quite a bit of effect with Congress in that venture capital is still exempt, and now smaller advisors to either private equity or venture capital funds managing less than the 30 million is off the table. So those funds between 30 and 150 are very excited, I guess. So that's the other point of note to understand. The third thing, and this is something that is a little troubling in the bill, is that there is the Advisors Act gives now the SEC authority to actually require more information than that is currently required under the Investment Advisors Act. They've added some language giving them that, in the public interest and some other amendments in that regard, but it's basically, it gives the government the ability to sort of request additional information from registered advisors in their sole discretion that would benefit the public interest. And I find that to be a little bit troubling, just in the sense that anytime you're giving the SEC a little too much discretion is probably not in their best interest. Some of the other amendments, that basically there was a test with respect to whether you qualified as an advisor to these funds. It was a test based on whether you had investors in the United States and 10% of investors. That was from the sort of the October bill. That actually goes away. So it's strictly now 150 million, advisor to hedge fund, private equity fund, need to register, need to appoint a chief compliance officer. That's basically, if there's one thing you go home with tonight, just remember that one sentence. Some of the other amendments, that basically there's a qualified client standard that's under the Advisors Act. In essence, those funds now out there who are fund managers who are currently managing, I think everyone's familiar with these 3C1 funds in which people are accredited investors. Now, if you're registered under the Advisors Act, the standard is up to a qualified client. The SEC has sort of given themselves discretion to now have the ability to sort of adjust that based on inflation, so they can somehow up the standard to sort of account for inflation. So that's another interesting thing to note. The one thing that I think is actually the other important thing to note from this bill from past Tuesday was probably hedge fund managers are most familiar with the Goldstein decision on how you define client. Is an advisor, who is the client? Is the client the fund? Is the client the limited partner of the fund? How do you define client? And was the essence of the Goldstein decision when everybody registered, and then the Court of Appeals said no, this is the SEC has gone beyond the jurisdiction. So the question really became, from the October bill, was how do you define client? The answer is client is actually, this is actually something that's fantastic for foreign private advisors. I'll talk about that in a minute, but basically client is defined as the fund, not the investor of the fund. So there is currently a private advisor exemption under the Advisors Act that currently allows hedge fund managers to not register. They've basically now extended that to foreign private advisors, and it's basically for those who are saying, oh, I'd love to, how do I get into that little loophole? Unfortunately, you cannot have a place of business in the United States, so for those who are interested in moving to the Cayman Islands and want to explore those structures, please give me a call. But I think that's, so that's the foreign private. So the foreign private advisor definition really follows this sort of private client, private fund exemption private advisor exemption that currently exists. So for those who are familiar with that basically extends to the foreign folks. Other than that, I think that the other two main really things to note is that the other change was from the October 1st proposal for and this bill passed, the House Financial Services Committee 67-1. It's going to go for a full House vote in November and then thereafter a Senate vote. So the other thing to note is that they have now given themselves 12 months to actually figure out the rules and regulations under this. I mean, the big question that everybody has is how do you define yourself as a how does venture capital how is that defined? What's the difference between a venture capital fund and a private equity fund? I see huge revenue generated by the Delaware Secretary of State with private equity managers trying to change their names to sound more like venture capital funds, so they could basically like plow through that exemption. So I think Delaware's excited about that additional revenue. And basically, the last thing to note is I foresee probably the effective date of this bill probably in December of 2009, perhaps January 2010, and you have, basically you have a year to comply. So they're giving you 1 year from the date of the passage of the bill, which it could be November, who knows? I mean, I think the fact that there's Thanksgiving coming up, and anytime you're sort of relying on the government to get things done efficiently is probably not going to happen that soon. So it's 1 year, and basically it's a straight test. 150 million private equity hedge fund manager, registered under the Advisors Act, and appointed chief compliance officer. So that's where my company comes in. We can provide comprehensive chief compliance officer services for advisors managing more than 150 million who are interested in outsourcing the compliance function and having someone who has 9 years of securities background experience instead of hiring somebody full-time, or instead of actually trying to task one of your employees who might not have a sufficient securities and experience with the SEC. So that's ARMOR Compliance. I really appreciate everybody coming tonight. I'm not really sure I'm planning to head out to dinner. I know that I'm going to be watching the game, and I hope that perhaps we can, the 6 years of therapy after Grady Little in the 8th inning in Yankee Stadium in 2003. I'm hoping that bad memory will go away tonight, because after he makes the Yankees down 2-0 against the Phillies. So thanks so much for coming. There's plenty of drink, and there's some food here as well too. And I think it's a great opportunity for folks to get to know each other. So thanks again.